Hello, good evening, and welcome to Mercantile Barristers webinar. Let me thank you for tuning in this evening to listen to what we have to say about avoiding disputes and payment delays in construction projects. As I say, it's my pleasure to welcome you, and I must particularly give credit to an architect who first wrote to me asking if we would be kind enough to put on these seminars. Originally, I replied to say that we hadn't started it, but as the request continued, my colleagues thought that it was a necessity. We've put on the first one, and hopefully this should be the first in a series of webinars that is aimed at practitioners in the construction industry. I must say that this is not aimed at solicitors in the main, because when barristers do conferences for solicitors, it is normally black law heavy, for want of a better expression. So I intend to keep it light this evening on the law, but specific on what you will find useful in your positions as either employers, architects, quantity surveyors, consultants, or even contractors in construction projects. So in making progress, I speak to you from a perspective of having spent quite a while in the construction industry, starting off as a quantity surveyor before becoming a project manager and then a barrister. So there is a degree of practical industry knowledge, as they say, having got your boots muddy before coming to the law. So I speak to you from both the legal perspective and the practical perspective. In starting off, as a quantity surveyor in the construction industry, one sees and encounters underestimating of work packages by those tendering for construction contracts. You can also, from time to time, see a degree of claims consciousness. And on the reverse side of that, you can also encounter inadequate budgeting in the commencement of construction or in the preparation for construction contracts. These are the issues that you see from that perspective. As a project manager, I see inadequate planning and programming, inadequate resourcing of construction projects, a particular difficulty in coordinating information during the construction process. And of course, there are always a necessity for contingencies. There ought always to be reasonable provisions made for contingencies. Now, in practice as a barrister, more often than not, when I receive a brief, by the time I have analyzed it, some self-inflicted injury will be self-evident. You will almost invariably conclude that neither side in the dispute had actually anticipated that things could go wrong, or certainly the way they've gone wrong. Ultimately, the dispute resolution process goes through up to the High Court, sometimes the Court of Appeal, and the Supreme Court. Of course, neither side wins. There is, of course, the high cost of dispute resolution, which everyone is aware of. Now, what are the consequences that you encounter as a result of payment delays and disputes? If you have not already experienced this, the likelihood is that it wouldn't take long before you do, because your cash flow will struggle. You will suffer loss of profit. We, of course, see from time to time contracts that are abandoned. More often than not, reputational damage is suffered. Future business opportunity is either jeopardized or lost entirely. And of course, there is always lost time, which is invariably irrecoverable. And you end up in litigation, which rather surprisingly is undesirable. So one key point to note is that be you the employer, be you part of the consultants team, or be you the contractor, you are participating in the production process of construction. So if you were to compare it with the aviation industry or the automobile industry where they build cars, the designers and the builders practically are often under one roof, pulling in one direction. The construction industry is unique, that there is that dichotomy between the design and ownership and the construction, the production process that delivers it. Now, what one then can deduce from that is that if the delivery process and the contractual provisions align, there are no difficulties. But when they don't align, you have a dispute. So in looking to avoid disputes in construction contracts, the first step is to try and understand the contractual stipulations. Then adapt your own processes internally to ensure that you can meet those contractual objectives. And you are a long way down the line to eliminating any difficulties that are likely to arise. So I'll give you an example. A recent brief that I'm working on kicked off like this. When the letter came in, my clerk passed it on. He said, "Dear Samuel, we're looking to get some advice, of course, regarding a project that has consistently gone downhill, both financially and contractually. Not unusual. They're, of course, in difficulty now already. Now, this is important, as I'm sure with most cases you deal with, this is not completely black and white, and I completely acknowledge that it is never black and white. Now, what's significant here is that this is, they've started the works under a modified JCT contract. They commenced and discussed potential modifications to the contractual terms, and it centers around design responsibility, which on this occasion, this contractor refused to take on. He says that from the beginning of the project, there has been a continuous interchanging of management and financial persons. He points out specifically there's been a lack of thought put in the pre-construction process. And this is significant because, as they say, if you have not prepared to succeed, you have in fact prepared to fail. So pre-construction is ever so important. He goes on to say that we were incredibly delayed on receiving the internal drainage design, which has caused them to miss all of the key project dates that was agreed at the beginning. And continuously, there is lack of detail required to build a project. Furthermore, they've undertaken additional works following the reissue and revision of drawings, and they stay unpaid. And the client is disputing the credibility of the variations that they have incurred as a result. They're reliant upon flimsy contract clauses. And there is an indication of the figure of the amount of variations that remain unpaid. He finishes up by saying, we're now past our initial agreed completion date, and there is the finishing date is not in sight. There are continuous hold-ups with other contractors on the project suffering the same fate. Now, it's important to pause here and see how many items that what starts as an innocuous, simple brief throws up. The project has gone downhill financially and contractually from the outset. There is ambiguity and uncertainty. It commenced in the middle of last year, is a modified JCT contract. Design responsibility is an issue. There has been a continuous interchange of personnel in management, and contractual management and financial management, source of difficulty. The key point here is lack of thought in the pre-construction process. There is a delay in the receipt of information. All project completion data on key milestones have all been missed. There are variations because drawings are being reissued, and it appears that those variations are not being paid for. There is a dispute, of course, as to who is responsible for them and who pays for them. And then with the completion date not being in sight, the typical lawyer will tell you that time is now large and multiple contractors have the same complaint. So these construction difficulties, when they arise, they don't come in self-contained packages. There are a multitude of items. And the key thing is, how do you actually manage them? Now, when you take construction projects, and I look at construction cases that I've dealt with and other reported cases that you may have come across, there are three cardinal points in every construction dispute. It always sits on a tripod of time, cost, and quality. They cause the most difficulties that you will encounter. They are the key characteristics of every construction project. So it's incumbent upon you as an employer, as an architect, as a QS, or any other consultant within the team, and indeed as a contractor, once you pick up a contract of these three cardinal points, which is the most significant, it's imperative that you must identify that, because more often than not, time may be more significant than the cost and the quality, because something must be delivered at a particular date. I once had to advise and indeed litigate on what was then deemed a premature termination of a construction contract, where the contractor was most unlikely to complete before the beginning of the September term, and the project was a school for blind children, a residential school for blind children. And there was no way the school term would be beginning without their residential accommodation being ready. So time was the key issue there. There are those that have costs and there are those that have qualities. It's imperative that you determine that. The three are all important, but one is often more important than the rest. Identify that and then begin to align yourself. You avoid disputes and delays by controlling your own internal processes and the contractual expectation. Because although the contract stipulates one thing, as we know, things happen from commencement to completion that takes you out of the, if you like, the fantastic tramlines within which you've anticipated the delivery. So, the project is supposed to go along this line. It never actually goes along that line because something always happens. You modify the contractual expectations, but you must also be modifying your internal process. Now, the internal process is not limited to the contractor, who has the primary obligation for delivery. If you are the architect that is responsible for information production, you have internal processes for delivering that. If you're the QS who is responsible for financial management, you have internal processes for also managing that, or will have to be controlled to create an alignment. So there is a degree of dynamism here because these are not static. So I give you some examples. Say, for example, pick time. I have attempted here to use pretty much in the manner of a plumb line, an arrow falling from at the top where you have the contractual provisions and at the bottom where you have the contract completing. If you are in the green zone, if you're on the green line, if you complete the project on the line that the contractual provision has stipulated, you have zero dispute. That is generated by the issue of time. So the more you deviate from it, so if you get into the orange zone where you have deviated by say 5, 10 or 15%, an issue arises, it may not necessarily finish in formal dispute resolution, but if you finish off in the danger zone, you've exceeded by the time by 50%, as quite clearly in the case that I'm presently working on. The contract completion date is far in excess of the contractual delays, more than 50% of the contract original contract program. There will be issues and there will be disputes. Now, I have highlighted, say, construction program agreement, which is important at the outset, a specified date of completion, which is very important at the outset. But what happens in the middle is the management of construction information flow. Now, if you want to ensure that you stay on the green line, you have to manage the flow of information, and it's a mutual responsibility. So in the example of the case that I have in hand, the contractor in that case is blaming late release of information. And of course, there are processes that would have alerted, a conscientious contractor could have alerted an architect as to when specific working drawings are required. And the architect can then adapt his own processes to fit that. So I give you that just as an example with respect to time. If you looked at cost, for example, there are a lot more things that cause you difficulty with respect to cost. Using exactly the same principle again, so you start the contract with the contract sum. Now, if the final account and the contract sum matches, you will be unique. You'll be in the top 10% of contracts that finish in that zone, because 90% fall out of the final account being far in excess of the contract sum agreed. But then, to the extent you deviate, the more you deviate from the contract sum. Of course, increasing costs is unlikely that the cost will be reducing in practical terms. The further away you drift from it, the more you are likely to be in dispute. There are a whole set of issues that are likely to take you there. But looking at the example of the case that we're dealing with, I've picked out specifically item 10, item number 10 on my slide. Item number 10 refers to having a methodology for recording contract variations. But it isn't just a case of recording those variations. You should also be nimble and quick enough to identify both the cost and the time implications of the variations. And once identified, it's not information to be internalized and retained. It is information that has to be openly shared with the construction team, and particularly with the employer, because you must get their buy-in. Because if we all agree that we are exceeding the budget, and we all understand that the budget is being exceeded by, say, 5 or 10%, and everyone has a buy-in, of course, agreement follows and disputes is likely to ensue. But if that conscientious attention to the management of deviations from the norm, or contract deviations in this case, are allowed to fester, then of course you have the makings of a dispute. Quality, the third tripod on which construction disputes tend to sit, is also an issue. Now, if you just sit back and look at it, most good contractors are very competent and are capable of producing good quality finished buildings to specification, provided, of course, they have the reasonable time that's been allotted to individual work packages to deliver them. Now, as we know, as most of us would have experienced, and particularly in the brief that I've just given you a snippet of, you will find that the primary critique there is lack of flow of information. So item number 9 on my slide, which highlights construction information management. Now, it is managing information, but if a work program that had 6 weeks to be delivered within the bar chart, due to late delivery of information, is constrained to 2 weeks. Now, it doesn't take a genius to sort out that the speed at which it's being done will mean that natural mistakes will happen, and therefore quality may become compromised. And indeed, I have been part of a project where you find yourself in such situations, and the question is, who then is responsible for diminished quality if it must be delivered within the time and the time is reduced and constrained? You may well find yourself, if you like, putting excessive resources in one specific work area. And of course, we all know what happens when you have too many cooks in the kitchen. The broth can become ruined as a result. So the fundamental reasons then for non-payment and reasons for disputes in construction contracts are often ambiguity. If there is an ambiguity, if there is a lack of clarity, as I say, A contract primarily is a legal document, but it is designed, it's intended to be a platform for a fair and reasonable distribution of risks and responsibilities between the employer and the contractor. Now, any degree of ambiguity in the contract terms and conditions, of course, is a fertile ground for dispute, and the risk increases the more or the higher the propensity you have to amend standard contract clauses, and particularly when those standard contract clauses have not been, might I say, altered and amended by a professional who has thought it through. Now, of course, there is the basic concept of contra preferentum, which will work against the person who has drafted it wrongly. So you have ambiguity, you have sheer failure, where the contractor simply hasn't delivered, and or the contractor hasn't delivered because those who owe the contractor information for him to deliver have also failed. And as we all know from practical experience, more often than not, leverage is used as an excuse for non-payment, or not an excuse, it's a reason for non-payment, because there is an argument coming down the line, and the greater amount of money we have up our sleeves, the more superior our position. So from the client or from the employer and the quantity surveyor's perspective, you downvalue the work that the contractor has done. You retain a lot more money up your sleeves. And from the contractor's perspective, they tend to front load to, as it were, claw back the profit as soon as they can, because the longer they leave it there, the more likely it will be caught up in the difficulty. So I come back to the key point: aligning your key internal processes to meet the contractual objectives, or indeed the expectations if those objectives have changed, will eliminate ambiguity, because of course you're getting everyone's buy-in at the outset. You start, of course, first of all, by getting your contractual clauses right. And then it will also assist you with eliminating failure, because your processes are designed to deliver when they're supposed to deliver. And of course, you are less likely to be at the receiving end of leverage. So there is the saying that a stitch in time saves nine. Now, I can tell you from practical experience that the cost of avoiding a dispute is a fraction of the cost of resolving a dispute. You do not want to be, if you can help it, in any litigation. So if you can anticipate the dispute coming, it is prudent to take steps to try and avoid it, because if you end up in formal dispute resolution, you may well find out when you have done the exercise of reconciliation at the end of it, that it may have cost you 10 times more than it might have if you took appropriate steps, as it were, to avoid those disputes. So I tell you, therefore, that the most valuable advice you can actually get from a lawyer is to avoid litigation. This is unusual, notwithstanding that what we do 24/7 is resolve dispute by way of litigation, or in some cases in construction is adjudication, arbitration, and then litigation. But if you can avoid it, you'll be far the better for it. Now, we have produced a checklist to help clients in the construction industry to avoid disputes. And if you're interested in getting this and learning more about it and how you might implement it, of course, if you send us an email, a member of my clerking team will ensure that you receive a copy, which will be, I hope, of assistance. So, as a barrister, therefore, I protect my clients in court when disputes arise. I can see the pitfalls as a quantity surveyor and project manager, and I know some of you are. I understand the realities of construction, the sheer practical difficulties that you face on site. I can therefore guide clients, be they professional consultants or the employers or the contractors, to actually anticipate where these difficulties are likely to arise and therefore take appropriate steps to protect themselves. And if they're able to do so, I said that would have been their own stitch in time. That would have saved 9. Now, as you can see, most people only consult counsel when things have gone wrong. I say it is far more prudent to consult counsel before dispute erupts, because if you're able to do so, then of course you will find that you would have saved yourself a great deal, if at all possible. So, as I said, we've written a checklist, which I'm certain is applicable to all. Whether you prefer to use the Mercantile checklist or in fact you develop one for yourself. Now, one thing is having the checklist. Another thing is implementing it. Now, being mindful that projects by their very nature are non-static. So your checklist mustn't be static. It has to be dynamic. It has to recognize at the outset what the primary characteristics in terms of time, cost, and quality of the project is, and then be adjusted dynamically to meet those in a manner that identifies where deviations and when deviations arise, and being able to share that with members of the project team, not just sharing it in terms of a one-way traffic, actually commit them to get a buy-in. Now, because if they disagree with you, they should tell you immediately. So we have therefore from that, a dispute avoidance protocol. It is aimed at eliminating ambiguity in your contracts. It doesn't mean that contracts won't come with ambiguity, they always do, but you have to be able to identify them, address them, and therefore you eliminate them. You avoid confusion on variations and additional works, because things will change. Some will be down to the contractor, but some will be down to the employer. It is imperative that it is understood when there is a change, the origin of the change, and therefore how it will be addressed. And therefore, you then would have enabled yourself to protect yourself from the deviations that may happen as a consequence of the variations and the impact on the construction program. Now, so you save yourself legal costs, you reduce and in some cases eliminate self-inflicted injuries, and then you eliminate leverage risk. And that is where you find yourself, quite frankly, in difficulty because you have done all the work and you have not received payment for it. Now, I bring that as a summary, therefore, for the webinar this evening without meaning to keep you too long. In summary terms, the takeaway this evening is to identify that there are substantial issues with disputes and non-payment. What part are you playing in that process? How can you, as it were, adjust yourself to ensure that you are not at the receiving end of it, and also not really altruistically, but professionally, that you're not course, and there are failings on your part, you're always the one that suffers because of non-payment, and therefore you have to step up to the point. So I draw the discussion to a close and bring your attention to the checklist, which is imperative that you have, either self-designed or the Mercantile one could be of assistance to you, and then you begin to implement it. And that, I will say, is the summary of what I want to tell you this evening. And of course, I'll be delighted to take specific questions. As it's customary with these things, I can say that, as you would appreciate, I'm unable to give specific legal advice on this issue on particular cases, but general points could be raised in which I can offer general opinion. as to any matter that you want to take up specifically, we will be happy to take that up individually and take it one step further. So I thank you very much for your attention, and I hope you found what you've heard fruitful, and to the extent that you're interested in more of this series and you have any particular burning subjects that you would want me to address, by all means, do drop us a line, and then we'll be able to take it and move it one step further. Thank you very much, and I'll hear from you.
Samuel, can I ask you a question?
Yes,
when you talk about the checklist, how do you realistically or practically implement the checklist?
It is actually very practical to implement the checklist because, as I've identified, within time, cost, and quality, there are key elements in the construction process that give rise to those difficulties. So the checklist requires you to actually identify those points and then adapt your own internal processes to actually implement it. So for example, the example that we have given, that client on their next project, they will not find themselves having implemented the checklist that we're working on, being 50% down the line with no clarity. So say for example, if you're on a construction program, it is also prudent to have an information requirement schedule, which should be shared with the architect and with the client at the outset. And then you get their buy-in. Now, that schedule, most architects mean to deliver the information on time, but you have to sometimes assist them by telling them what that time is. So if you sit back there and don't remind them, there is no contractual obligation on you to remind them. But if you have a process that pings a reminder, look at my schedule, I need that information on Monday, the 15th of June, so that we can start the activities on the 20th of June. All of a sudden, people are conscious. Even when the architect is not ready, they may give you the information partially, but then they release it as you build, rather than wait until after the event and then you turn around and say that it hasn't been delivered. Now, some architects may also turn around and say, okay, you have the design drawings, but with respect to working drawings, production information, I need you to let me know when you want them so that I can also adapt my own internal resources to match that. And then they'll be able to meet that objective. That's only but one example. And there are a whole host of ways that we do that. But they are often, although you have a global checklist, then you adapt them to your specific project requirements. So you've got to stay awake and keep moving it on at the same time. So that is how we implement it practically. We just guide clients to do so, and you find that all of a sudden, rather than people falling out, they begin to appreciate, if you like, the early warning signals, for want of a better expression.
Thank you.
Good.
So, sorry, Samuel, thank you for your lecture, if you like, almost. What you were just mentioning, that sounds like to me what would normally be deemed within the realms of a design and build contract, where the contractor would issue an information release schedule to alert the architects and any other consultant the type of information that needs to be issued at a certain time. However, my question actually is more specifically, within your experience, what are you finding as the cause of most delays? And I say this in the sense that as an architect and someone who's worked for a main contractor on the other side, one of my biggest headaches were actually architects. And it was actually to do with the release of information. So I'd like to understand from your perspective, what are you finding in the industry at the moment as, let's say, one of the main causes for disputes?
Okay. Information, lack of information is a critical, if you like, defense mechanism for the contractor. So I've just put up the brief, one of the matters that I'm working on. Now, as you can see, I believe in I believe the fourth or the fifth paragraph, you say we were incredibly delayed on receiving the initial drainage design.
Yeah.
Now, that is the fountain of the difficulty because they're in the ground. And of course, they have to get the drainage in the ground before they can then start covering and coming up. The key difficulty, if I may put it this way, architects design fantastically. They require assistance with the timely production of information to match the construction program. More often than not, one sits back and asks, how many members of the construction team actually have a full appreciation of the construction program that the contractor has produced? On reflection at the outset, very few, because there are very few that actually challenge the contractor. Now, it is rare when in the if you like, rare situations that clients invite us to attend certain site or project meetings, a program is produced and there is no challenge on the contractor as to why this activity is happening before this activity and why this is given this duration and that duration. So, and forgive me for a minute here, let me get into project management mode. So when you have your bar chart program, you identify the critical path in the construction program in order to hit the contract completion date. Now, very few consultants that I have seen are actually challenging the accuracy of the critical path, because for you to challenge the critical path, you have to understand it. And you have to challenge your contractor and say, you've given me a program, what is your critical path? Critical path, if you like, on your critical path would be those construction activities which have zero float. In other words, any day or week's delay on those will sound to the end date. So for example, if you're doing a structural steel frame building, if in the cladding there is a little bit of delay, provided the primary structural steel is on and the roof is on, all other internal activities, as you know, can be released, provided they are not subject to negative impact of the weather. So on such a project, one sits back and, you almost want your architects to be asking the contractor, how do we get weather tight as quickly as possible? How do we get to the roof as quickly as possible? And prioritizing all the information on the critical path. Once that is released, you have largely secured, as it were, your contract completion date. Any other deviations could be coped with. So you answer that question yourself, actually, when you say you're an architect, and then architects frustrate you. But then you can't blame architects for all of that, because
I certainly don't.
Yes, good. Their primary training is in design and the management of the full construction process. Ideally, should rest with the contractor or the project manager. But as an architect yourself, as you know, imagine the architect in this scheme, the blowback that they'll be getting from the employer when it is demonstrated that it was the late release of information that has now precipitated the delay. The employer will turn around and say, well, I'm paying you to release the information. Why did you release it late? I have dealt with another matter where due to delays in the release of information, the contract was delayed, the contract was determined, and the contractor brought an adjudication seeking £2 million from the employer for the delays caused due to information. And in the course of that, the employer turned around and served a notice on his architect. If I have to pay this $2 million, it's coming off your professional indemnity cover. As it transpired, it was actually the architect that sought to retain me against the client. I advised them that it might be wiser for the employer to retain me against the contractor, because if the original dispute could be killed as source, then you don't have the difficulty with late release of information, which you definitely are unspeakably responsible for. So
Yeah.
I hope I haven't taken that too far. What's your own experience? Tell me.
Well, I've been 20 years in the industry as an architect, worked for a main contractor. I've actually been through 2 adjudication processes,
Okay.
one earlier on in my career under traditional contracts, and the contractor had furnished me with quite a heavy document quoting clauses from the contract. What he didn't bank on was the fact that I actually enjoy law and contracts.
Oh, fantastic.
So I was able to assist the QS at the time, and we won that case and another case.
Fantastic. Congratulations. Very well done.
You.
You thoroughly enjoyed that one.
Yeah, well, as I said, I do enjoy law.
That's good.
So, yeah.
Excellent. Yeah, ought to perhaps be a little bit of it sprinkled in the course of educating consultants across the board.
So I was very keen to join your webinar.
Oh, it's a pleasure. It's a pleasure. I hope what
Thank
you've
you.
heard is of some benefit.
Thank you.
Good. Excellent. Any further questions? I have a lot of people listening intently. You're most welcome to ask questions, and don't feel shy.
Samuel, I have one, but you may not want to answer it.
Oh, try me.
So the legal industry is really kind of geared up for dispute. What's your motivation? And maybe you've answered this at the beginning of your webinar with the project manager QS role. Why would you want to avoid litigation?
Well, if I'm being perfectly honest, counsel, I'm designed to fight. I don't want to avoid litigation. That's my day job. But in reality, why is counsel always you advise your clients in their best interest? I have advised many clients and have seen a lot of bankruptcies and the multitude of risks that some of which I've highlighted in my dispute avoidance protocol pamphlet, the consequences of getting into disputes. Now, as I said, it is far cheaper for you to save money in avoiding a dispute than getting into it. My motivation is largely from the client's perspective. You give best advice. There are people who get into difficulties that are entirely avoidable. Now, advising you for 3 hours of my time and you avoiding engaging me for 30 hours of my time subsequently, I would have thought you would appreciate as the client. Not that I'm, of course, the more of that advice you get, of course, the more likely you are to want more. But I always say that the value of any good lawyer is what they add to the bottom line, not what they take away from the bottom line. And I've been out there in the industry. I have been part of raging disputes that have cost hundreds of thousands of pounds. And it goes without saying that from a client's perspective, a stitch in time should always save 9 down the line. You should always avoid a dispute if you can. Yes, the legal industry, is designed to resolve disputes, but taking specific interest in construction, and particularly through my career path of having seen it from ground up, I think it's far more valuable for the industry to learn to dispute less, because ultimately you profit more if you dispute less. And that's why I give the advice. I have, of course, I started doing this because clients asked for it, but I think you can see the benefit for them. I hope that's a good enough answer for you.
That's great, thank you.
Indeed. Okay, do I have any more questions?
Sorry, Samuel Jermaine again. Just
Yes.
one more question. Sorry. If disputes go to court, does it always, and forgive me for asking, I'm just not sure, do they always go to the technical industry courts, or is it something else?
Does it always go to
is it technical
the
industry
Technology
court?
and Construction Court?
Yeah.
Right, of course. The Technology and Construction Court is a specialist division of the High Court that deals almost exclusively with technology and construction matters. Yes, if he goes into a different list, we have the Chancery Commercial Division. If he goes into a different list, if it is seen to be a construction matter, you will find that it will be routed back to the TCC for it to be dealt with, because the judges in the TCC are specialists, if you like, construction barristers that become judges. And some of them, you will find the odd one that has a background in construction, and they're deadly specialists on the subject. So that's where it goes as a matter of allocation.
Right.
That's where it should go.
Okay. Thank you.
Because it actually assists the speedier resolution of the dispute, because the people that will be engaged in dealing with it are specialists in that field.
Sure.
Because as I'm sure you will appreciate, more often than not, counsel will have to guide the judge as to what the law is that will be applied to the facts and the evidence that's been adduced. And if all are singing from the same hymn sheet, then all the better.
Yeah. Thank you.
Good. How are we doing on time, gentlemen? Can we take one or two more questions if there are, or otherwise? As I say, at the end of this, I believe the slides should be available for anyone who is interested in them, and my clerk will gladly send them out. And then, as I mentioned, as we're putting together and contemplating future webinars, any specific items of interest will be welcome, so that they are, if you like, addressing the questions that you are concerned with.
Samuel, I promise I won't ask for legal advice, but
you promise you won't ask for what?
Legal advice, because you said at the beginning you couldn't give it. But
I ought not to give it in such circumstances. But yeah, go ahead.
I heard a rumor that if a lawyer gives you free advice, you're still legally responsible for the advice you give, right?
In some contexts, yes, you're right.
Okay.
Is that the same as architects?
So as architects, well done, Jermaine,
Yeah.
because they're professional people. If they knowingly give advice and appreciate that you're going to rely on that advice, then the consequences that flow from that advice rest with them, and it is immaterial whether or not they were paid for it.
So my question is, well, there's two questions. The first one is, and you know, this is the impossible question, but I'm going to ask it and hope you answer it anyway. You get through adjudication and you've still not got to a point where you're happy with it. Have you ever got a different outcome than the adjudicators by going into court?
Oh, yes.
And what's the potential if somebody has to go all the way to fight this to court? And again, how long's a piece of string? But what do you need to bear in mind from a cost point of view of if this ends up in court? What's the, I know the ballpark, how big's the site, what's gone wrong, all of those variables, but can you speak into that?
I can give you general observations, but not specifics. Now, adjudication is supposedly a rough and ready approach to arriving at a resolution by technical people, which keeps the wheels of the industry moving. Now, but that rough and ready resolution must also be done in accordance with the law. If a rapid adjudication, which is supposed to produce a decision pro tem, produces a decision that is inconsistent with the law, then that adjudicator's decision may not become enforceable. So assuming you were B, that receive, A and B are in dispute, and B receives an adjudicator's decision that they don't like, and they find, if you like, legal errors in them, they may refuse to comply with that decision. What is then left is for the beneficiary of the adjudicator's decision to bring the matter to the court, seeking an order to enforce it. And that enforcement can then be resisted by the party at the receiving end on the basis that the decision was unenforceable. If indeed that decision was unenforceable, it collapses, that decision cannot be enforced. So the victory secured may well become a Pyrrhic one. Now, if the matter was then to proceed to the High Court, of course, the costs then rise quite significantly, because in adjudication, it is a largely informal procedure where the adjudicator himself will set out the procedure that should be followed. Now, of course, once you get into the court, the civil procedure rules kicks in, and you have more serious engagement of legal practitioners. Now, which is why some people who become engaged in adjudications engage legal practitioners at the outset, because that way they believe that they're avoiding the likelihood of securing a decision which is unenforceable, and being clear as well that if they have to resist a decision, they're going to be resisting it on very sound lawful basis. But the costs of the litigation then become quite significant, of course, when you go to the courts and taking it all the way. Now, far be it for me to say what the cost of completing a litigation might be, but you can take it from me that is most likely to be in the tens of thousands rather than anything less. I hope I've spoken to that as globally as I can, giving you the direction rather than being specific. Correct?
Yeah.
Okay, yeah, go ahead.
Whenever I've interacted with solicitors, so I know you're a barrister rather than a solicitor, but whenever I've interacted with a solicitor, it's always been a little bit vague about how this case will play out. Do you, given you're a barrister, so you're effectively a more senior legal practitioner, I might have offended some solicitors there, but how do you work in terms of determining what's worth settling, what's worth pursuing? Can you give any guidance on how you work with that?
It is right to say that barristers are more specialist lawyers than solicitors, because largely the bulk of solicitors take a general practice approach, whilst the greater number of barristers are specialists in their areas of practice. And let's face it, the barristers end up arguing the cases in court, and therefore they ought to be more up to date, as it were, or more specialist in how they take it forward. So that was the first part of your question. What was the second part of your question again, Dean?
It was really in how do you gauge which ones you should fight and which ones you should settle, and where the success line is, and having a realistic understanding of, sometimes you want to fight to win, don't you? But there's pragmatism.
Yes, I once gave advice in conference. I think this is as good an example as I can recall instantly, where a solicitor brought his client in and we were reviewing their case. My approach to advising clients is to go back to the basics, because practically all cases have essential elements. So if you want to sue for a breach of contract, there would already have would have been a contract in place, and you would actually be able to pinpoint the elements of breach, where and how they took place, and then be able to bring it back to the damages that you're seeking. What I do as counsel is to analyze the cases that I receive to establish the existence of the essential elements in terms of facts and in terms of evidence. And then one sits back and reflects on what the current law is. What is the precedent that has been, and how does it apply in these circumstances? And largely, you will find a degree of consistency that gives you a degree of confidence to advise that should this matter come before a judge, an objective judge will treat these facts in the following ways and look at this evidence from this perspective and will apply this relevant law in order to reach a conclusion within this band, within this band. Therefore, there is always, in the advice I give, a prospect of success assessment where I say that should this matter come before a judge, the prospect of success is high, low, or non-existent. And yes, on one occasion where I've given advice to a solicitor and his client in my conference, I've concluded that they had less than 20% of the essential elements required to prove what he had to prove in order to win. And as such, I had no hesitation in advising that the case had very limited prospect, if any, of success, which was rather a surprise to both my solicitor client and my lay client. But at the same time, what happens more in reality is that when they come to you, be it claiming or defending, they're in the process. You can say, although the essential elements are not in existence now, if you take these further steps and can establish the following and can identify the following and tease out the following, then you may be able to do so. So it will be a case of returning to the source and extracting what is in existence and then being able to bring it together and then reevaluating the case. And then you may well find that the prospect of success rises quite significantly. I'm dealing with a matter presently where, if you like, the employer is suing the contractor. The contractor alleges that there are 4 nominated subcontractors that actually did the work that the employer is complaining about. And believe it or not, 3 of the 4 subcontractors are available, ready and willing to give evidence on behalf of the contractor. Their availability and willingness to give that evidence, which has been teased out subsequent to initial conferences with me, all of a sudden changes the prospect of the success of the defense in that case. So how one works with it, of course, I'm sure that solicitors will appraise the case as they see it. And many solicitors will also come to counsel and say, this is the situation we have, what do you think? And most solicitors are upfront with their clients to say, look, we have to go to counsel to get advice on this. And when they come to you to give advice, and that's why they come, and you do your level best to ensure that you give them quality advice, which hopefully should score a win at the end of the day. So I think that brings us to the hour, and I'm grateful for all of your attendance, and hopefully I look forward to speaking to all of you again. And once more, do not hesitate to make contact if you should require any further information or indeed assistance or require any other slides, and my clerk will oblige you. Thank you very much, and thank you for attending. Bye-bye now.